chairperson of the IEC, all commissioners and the executive, morning to the Parliamentary Legal Service, the State Law Advisor and colleagues. Mr. Matonzi, I'll also switch off the video. The load shedding is just started now so that I'm not disrupted. We are going to continue with the briefing from all the stakeholders as indicated. The IEC, Parliamentary Legal Service, the Minister of Home Affairs, and I'm fully aware that the Minister has requested an apology to brief us before he attends the Cabinet Lekgotla. We'll quickly run on the apologies, Mr. Matonzi, and then we'll introduce the team who are in attendance from the stakeholders. Then we'll directly go to the presentation. I think we're fully aware that there were issues raised yesterday by members on the issues that are related to the presentation that was presented by Mr. Salmon. I hope that as they respond or present, they'll also interact with those issues that were raised by honorable members. Mr. Matonzi?
Yes, Chairperson, from my side, there's no apology from members, even from the stakeholders. Thanks, Chair.
Okay, thank you. Minister, can I get indication who was in attendance? Deputy Minister? Director General?
Good morning, Chairperson. Good morning, honorable members and the other stakeholders, including the colleagues from Parliament and the IEC. There's no apology from our side. I think the Minister is trying to connect, is actually connected to the meeting, Chair. I suppose there's some intermittent disruptions, but I'm here together with Michelle Dibier and also the colleagues from the Ministry, Mariette Magua and Santos. Thank you, Chair.
Okay, thank you. Commissioner Mieta.
Good morning, Chairperson. Good morning, honorable members, the Minister and his team. We are all here, members of the Commission, our CEO and his team. As I indicated yesterday, our senior management is following these discussions as well. Thank you very much.
Thank you, Commissioner. Parliamentary Legal Service.
Good morning, Chairperson. It's Talana Hali-Starkey here and Ms. Daksha Kassan. We will be representing Parliamentary Legal Services. As you know, Chairperson, Mr. Njikile is still off sick.
Thank you. The State Law Advisors.
Good morning, Chairperson. Good morning to the Minister and the rest of the colleagues and stakeholders present on the platform this morning. I'm Sarah Govender from the Office of the Chief State Law Advisor. With me present this morning, I have Ms. Aisha Johar, and on the platform, we also have Ms. Harriet Mekwa.
Thank you, colleagues. I'm sure there are no apologies from members.
Yes, Chair, I didn't get any apology.
Okay, thank you, Mr. Matonzi. Minister, we're inviting you to present on the issues that were raised by the members of the public.
Hi, Mr. Chair. I've been delegated to respond to the issues that were raised by members of the public.
Can I speak first?
Apologies, Minister. I didn't mean to jump in ahead of you. Apologies, of course.
Yes, yeah. No, thank you very much.
That's the reason I invited the Minister, so that he delegate.
Yeah, exactly. Sorry for that, yeah.
Apologies, Minister. That's my fault, and Mr. Chair. I will turn off my camera now.
Yeah.
Thank you, Minister. Proceed.
No, Chairperson, unfortunately, I'm starting with an apology. I'm here at the presidency for the Cabinet Lekgotla. I've just been released from the Cabinet Lekgotla just for 2 hours. If it is possible, Chair, I just want to ask for that. In the meantime, the report that we have got here in front of us, as already announced, will be given by Mr. Advocate Michelle Dibier. Let me not waste time with preliminaries, especially that I've asked to be released. Let me ask him to shoot on straight away. Advocate Dibier, please.
Thank you, Minister, and apologies for jumping the gun there a little bit. Mr. Chair, I must just apologize that I wasn't in the meeting yesterday, so I can't respond directly to questions and queries raised by members of this committee in this presentation. And I'm just going to be focusing on the public comments that were received. Mr. Budlander and I prepared a memorandum. We prepared it yesterday. We finalized it yesterday. I'm not sure if the chair has it. We don't need to put it on the screen. And I just want to address really briefly what we looked at. The committee will know that this round of public participation was really focused on the new matters that were introduced into the bill by the National Council of Provinces. And there's sort of three big headings. One was the question of how the eligibility requirement, the signature requirement, will work going forward. And now two things were changed from the National Assembly's bill. One is that the signatures requirement will be required for both political parties and independent candidates who are not already represented in the legislature concerned. And then the other will be that once a political party or independent candidate is in the legislature, they don't have to satisfy that requirement again to contest the next elections. And then the second big change was the introduction of the reform panel. And then the third change dealt with the calculation, the allocation of seats. Now, Mr. Budden and I focused on the first two. And as far as I understand, the Commission has, as the party that's, or the interested stakeholder that's most close to that issue, will be dealing with that. Now, turning to the voter or the eligibility requirement, I'm just going to pull up the memo quickly on my side. The comments were received again about how a signature requirement would create barriers to entry for independent candidates. And we repeat again, in our view, that it's constitutionally permissible for Parliament to adopt eligibility requirements for any candidate or political party wishing to contest an election. And I just want to make this point quite strongly now. The point is that when one has a representative democracy, as we have in South Africa, we vote for our representatives. We don't have a direct democracy where every single person votes for every single decision made by Parliament. We have a representative democracy. Now, the way the democracy works is that there are elections to contest the seats in the representative legislature. And of course, there has to be some kind of limiting factor or requirement as to who can contest the elections. If every single South African citizen could put up their hand the day before the election and say, hey, I want to run, that wouldn't work. We know that. So it's perfectly constitutionally permissible for Parliament to say, we're going to have certain requirements that you must fulfill in order to be eligible to stand and for a seat and contest the election. And of course, Parliament, the National Assembly and the bill, and the National Council of Provinces now has adopted this signature requirement. And the way I think we can look at it is as a sort of proof of concept. It's to say, before you can contest an election, you've got to demonstrate that you at least have some kind of support, that you have a chance of actually getting enough votes to get a seat in the National Assembly or the provincial legislature concerned. Of course, we have to strike a balance. We can't preclude people from participating unjustifiably, and on the one hand, but on the other hand, we've got to make sure that persons who are contesting elections are actually serious about it and they have a prospect of being elected. And ultimately, Parliament is the body that's going to make the choice about how to determine that requirement. Now, the initial bill, as members of the committee will know, suggested that the Commission be empowered to prescribe this requirement. And that's not what Parliament has chosen. Parliament has chosen instead to adopt a percentage of the quota, previous quota, or a seat in the relevant legislature or the relevant election to demonstrate voter support. And of course, it's constitutionally permissible for Parliament to do so. Parliament's landed at 20%. And Mr. Badlin and I have expressed the view now in this memorandum that 20%, which is it's 1/5 of the votes required for the previous election, is constitutionally permissible. I must just address one matter, and that's in previous advice, we had spoken about, we'd used a quota of approximately 44,000 votes for a seat. And that worked out, I think, at around 8,000 signatures if one used 20% as the number. And there was some comments received that, well, the quota may not be that low, it may be higher for the regional seats. It may be more in the region of 80,000 votes per seat. And what Mr. Budland and I have just stressed in this latest memorandum, and I'll stress now, is that when we were referring to the numbers before, the numbers of votes, our focus was not so much on how many, what the numbers would be, whether it would be 8,000 as 20% of the quota, but our focus was on the percentage of the quota used for determining the eligibility requirement. Now, members of the committee will know that at one stage there was a suggestion that it should be 50% of the quota. And then I think it went down to 30, and now the Parliament has landed, the National Assembly and the National Council of Provinces have landed at 20%. What Mr. Budlin and I were saying in earlier memorandum was that 30% may be too high. It may be found to be too high. And the reason for that was simply that, of course, one can't equate voting with canvassing voters vote signatures for support. So it makes sense to have a percentage of the quota as the signature requirement. We've also expressed the view that if Parliament is concerned that 20% is too high, it might consider reducing it to 15%, but ultimately that's for the National Assembly and this committee to make that decision. Minister, I just want to, Minister, can I just finish one more thing?
Oh, yeah.
Thank you very much, Minister. I see. I think the minister got a phone call. The other thing to mention and just emphasize is that the signature requirement now applies equally to every new participant, any new political party who's not represented in the legislature or independent candidate. And the signature requirement, in a sense, it's not a once-off, because I, for example, might decide to contest the Gauteng provincial legislature. And then I might decide, well, now I want to contest the National Assembly as an independent candidate. Then I'd have to satisfy it both times. But the amendments that were brought about by the National Council of Provinces have brought parity between parties and independent candidates on this score. The second matter for me to deal with is the reform panel. Now, committee will have seen that the suggestion for the reform panel is so that there can be a statutory body mandated with investigating electoral reform over a longer period of time than has been possible since the New Nation Movement judgment was handed down, and the requirement that for the 2024 elections, independent candidates be included in be entitled to contest the 2024 general elections for the National Assembly and provincial legislatures. Now, the ministers made the point, and I'll make it again. Before the New Nation Movement judgment, the electoral reform that was done or investigated was usually by not statutory panels, but panels appointed on an ad hoc basis. And like the Van Zyl-Slabbert investigation, and our former president, Kgalema Motlanthe, also had an investigation. So the one thing is that those were ad hoc investigations. They weren't statutory investigations. And they also didn't consider this question of how to fit independent candidates into the electoral system. The electoral reform consultation panel that the bill will introduce will be a statutory panel with a mandate from Parliament to investigate these issues. There were two queries raised in the public comments generally about the panel. One was a question about the timelines of the panel's work. Some parties said that they need to be curtailed, and others said it should be lengthened. Of course, again, this is why we have Parliament to make these choices. But if one looks at the timelines for the panel, essentially what will happen is when the bill comes into force, which will have to be by the end of this month, because the Constitutional Court deadline will expire, the minister has a 4-month period to establish the panel and appoint its members. Before next year's elections, the panels must undertake research into these issues, and after the elections can then facilitate a public participation process about broader electoral reform. And 12 months after the election, the panel has to provide its report on further reform. Now, the reason why the panel is mandated to do public participation after the 2024 elections is that at that stage, the country will then have had an election for the National Assembly and provincial legislatures where independent candidates have contested those elections. And of course, a year after the 2024 elections, when the panel must provide its report, that will give Parliament and the minister a period of 4 years until the next election to undertake any further reforms. And the way we see it, will probably be about 3 years, because the Commission may require time before the 2029 elections to update any system in light of any reforms that are adopted. So it's a much longer period of time than has been available since the New Nation Movement judgment was handed down in June 2020, which requires Parliament to enact legislation that deals with or permits independent candidates to contest the elections for the National Assembly and provincial legislatures. A second theme that arose in the comments was the question of why the minister is appointing the panel, and why not Parliament. Questions sort of been, well, Parliament is responsible for passing the law, so why is the minister appointing the panel? And really, there are a couple of reasons for the minister to be involved. There's a practical reason, which is that the minister's department can provide administrative support to the panel. His department is set up to do that already. But also on a principled reason, the minister is the person who will be introducing legislation in respect of electoral reform going forward. And we know that's how Parliament works. I've just got section 73 of the Constitution before me now, and it contemplates the cabinet member or deputy minister or a member of the committee of the National Assembly may introduce a bill in the Assembly. And we know that generally speaking, it's the minister responsible for that legislation that will be introducing it. So that's why the minister, those are the principled and pragmatic reasons why the minister is appointing the panel. But we just wanted to emphasize that the way the panel has been drafted is that the panel is not appointed by the minister and to report to the minister. The minister doesn't have a free hand in appointing members of the panel. So the statute provides for specific qualifications. So you must be a fit and proper South African citizen. You must have skills, expertise, experience, knowledge, or academic qualifications in elections or constitutional law. You must not be a member of Parliament or provincial legislature, and you must not have been in the past 12 months an office bearer or employee of a political party. So the minister has to appoint specific people with specific expertise. The second constraint is that the minister must appoint from nominations received from the public. And the third is that the minister's appointment, he doesn't do it by himself. He appoints people to the panel in consultation with the Electoral Commission. And a requirement to appoint or make a decision in consultation with, it requires agreement with whoever you must consult with. The minister also can't just remove members of the panel. There has to be a finding of misconduct, incapacity, or incompetence. So while the minister is appointing the panel, the panel is going to report to the minister, there are independence mechanisms to ensure that the panel does its job and can report to both Parliament and the minister once taken everything into account. There's nothing untoward about the minister appointing a consultation and investigation panel, especially in circumstances where the statute will be very specific about who can be appointed and what their role should be. So those are our responses to the public comments received from Mr. Balinda and my side. As I said, we have prepared a written memorandum, and I'm not sure if the members of the committee have received it yet, but that does expand on what I discussed now. Thank you.
Thank you very much, Advocate Pierre. Mr. Matonzi, before we proceed, can I check if all presentations were received? I've tried to interact with you early hours of the morning.
Chairperson, I did receive IEC and Parliament Legal Service yesterday, and I sent them out. And then for the department, I just received it now. I've sent it on WhatsApp onto the group.
Okay, I think members, you'll note that we'll establish how we'll interact with this matter as you input. Yeah, thank you, Advocate. Minister, is anything you want to add before I invite the next presentation?
No, Chairperson. I think Advocate Dibia has presented everything that there needs to be. Will just be available to answer questions.
Okay, thank you very much. Next presentation is Parliamentary Legal Service, Mr. Matonzi.
No, the next presentation is the IEC.
Okay, yeah. Commissioner Mierta, Chairperson.
We are going to deal with the 3 issues that we believe are allocated to us, and to do that, the CEO will do, will make the presentation straight away. Thank you, Chairperson.
Thank you, Commissioner. CEO Mamabolo.
Thank you very much, Chairperson of the Portfolio Committee, Dr. Chabane. We extend greetings to all members of the committee and every stakeholder on the line. Same with Minister and the DG. We're putting the presentation we're projecting it in a minute, Chair. Sorry for the delay. To save time, perhaps I should get on with it as we're trying to get the projection going. The first issue really that the Commission wishes to address relates to the question of the wrong quota that presumably the committee worked on. And in this regard, Chair, we want to remind the Portfolio Committee that on the 5th of July, 2022, we did present to the committee 20 million regional quotas. And we what the signature threshold would be at 50%, at 30%, at 20%, and at 15%. And the committee exercised a preference, having seen those regional quotas that we presented on the 5th by 2022. Similarly, in the NCOP, we did present the regional quotas. So the So the NCOP itself would have been a privy to the correct quota information when they deliberated on the bill. And what we now have on screen, Chairperson, is the slide that we presented to yourselves on the 5th of July, 2022. And it does indicate the regional quota for each province and what the signature.
My apologies, Chair. Apologies, Chair.
Of the committee or IEC?
No, Chair of the committee.
Thank you.
Yourself, Chair. Yes. I don't know whether it's only me. I can hear the CEO of the IEC saying on the screen, I've got nothing on my screen. If it's only me, I don't want to waste time for the committee, but there is nothing, I can't see anything.
Okay. Chair, we'll ask Eddie to project it on our side. We seem to be having a technical glitch. So can we ask Eddie to share on our behalf?
Okay. Noted. Mr. Mr. Matonzi, can we just 2 minutes or 3 minutes project the presentation? We can also follow. Yeah. Sorry, CEO for that.
Not a problem, Chair. Thanks.
Mr. Matonzi, are you? Yes.
Are you able to see something on the screen?
Yeah, but you don't see the content of the presentation.
Okay, I don't know what's going on. I'm able to see this slide.
Okay, Mr. Adams, are you in the meeting?
Yes, Chair, I'll try and present as well.
Please.
Eddie, just allow me.
Okay, no, I will do that, Adam. Quickly, just hold on. You are a co-host, Adam?
Okay. Okay. Eddie, on my side, my PowerPoint is updating, so it's just going to give be a couple of minutes. I think let the CEO continue so long, and we'll project as soon as they're able to. Or Eddie, can you try again? I'm sorry, I think it's going to take a couple of minutes. Oh, there's Muzi sharing.
Yeah, no, I think thanks, colleagues. CEO, you can proceed. Thank you. Yeah, CEO, you can proceed.
Can you get it on the screen?
Yeah, I think the CEO was on the second page. Yeah, thank you.
So I'm not sure now if everyone can see.
Yeah, we can see. All of us, we can see. Yes. Yes, who's on the platform?
Chair.
Yes, proceed.
Eddie.
CEO. No, can see the presentation, colleagues. Commissioner Mepsa?
That's sharing. It's Adam.
Oh, that's what I'm saying.
Chair.
Yes. Commissioner Miepza? Commissioner Miepza?
Hello, Chairperson Eddie.
Yes, well, we can, without the presentations on screen, we're waiting for you to proceed, the CEO.
Eddie, can you hear us on your side?
Yes,
But we can't hear you.
but you can respond to me.
Can you hear us now?
Yeah, no, we can't. You are muted.
We are not, I'm not
But
muted.
But how you confirm that is muted when we say, when you
Now
say no?
but we still can't hear you.
Let's all be together.
Commissioner Miepza? Mr. Matonzi?
Chairperson?
Yeah, what is the problem now with the IEC?
I think they have got a problem on their side.
The network?
Yeah.
Yes.
It could be a network issue.
You know what? They're here. You can present. You can sit here.
Chair, we back online.
Okay. Yeah, I can hear you now.
Thank you, and we apologize, Chair, for the technical glitch.
No problem. Can proceed, CEO.
Yes.
No. CEO, we're proper. I think you are being disrupted where you are.
Okay. No, that's
Okay.
fine, Chairperson.
Okay.
All I was saying. Yes, thank you very much. As I was indicating, this regional quotas based on the 2019 results were presented to the Portfolio Committee on 5th July 2022. And we gave a range of what the signature requirement would be at 50%, at 30%, at 20%, and even at 15%. The committee then exercised a preference and determined the threshold at 20%. So that's just a factual matter that we wanted to place before the committee. Now, one of the submissions takes issue with the fact that in the NCOP, we had made a proposition to the fact that the same signature requirement must apply to unrepresented political parties. That was not to bring a policy proposition on the table. It was rather to propose the extension of a policy proposition and make it applicable across all electoral contestants in order to realize parity of treatment amongst electoral contestants. That's really what the commission sought to do. Eddie, we can go to the next slide. Now, this slide deals with forfeiture calculation. Now, forfeiture calculation arises in two circumstances. The first circumstance in which forfeiture arises is when a party has tendered less candidates than the seats
they have allocated. That's the one instance in which a forfeiture calculation eventuates. And then the second circumstance where a forfeiture calculation may be required is if an independent candidate win more than one seat. So in both circumstances, a forfeiture calculation will be required. Now, since the dawn of democracy in South Africa, never have we had to do a forfeiture calculation, meaning never has a situation arisen where parties give you a list with fewer names than the actual seats they won. So the likelihood of a forfeiture calculating arising in respect of political parties, in our view, is almost it's unlikely. Well, it's an unlikely scenario given history over close to 30 years of electoral democracy in the country. Now, the possibility that an independent candidate could win more than one seat, it's real and can materialize. And when you do a forfeiture recalculation, it is correct that you're lowering the quota because you have to exclude the votes for the independent candidate who gained more than one seat. And you've got to reduce the seats by one. So the effect of that will generally be lowering the quota. Now, this is in fact acknowledged in the submission that we received, that states that independents are potential victims of this. But similarly, parties may be potential victims, and the argument can really go both ways. And we will show in the next minute or so that the possibility of a provisionally assigned seat might change hands, especially if that provisionally assigned seat was on the highest remainder. So it's possible that you may lose a seat that was provisionally assigned. And here it's important to state that until the commission, no, don't move yet, until the commission has published a final seat assignment, it means the election has not been finally determined. So the provisional assignments that happen don't amount to a person losing a seat because the commission at that point is yet to determine finally its seat assignment. So if you get a seat on a highest remainder, you assigned a seat, provisionally assigned a seat on a highest remainder. During the forfeiture recalculation, political contestants could either gain or lose a seat depending on the outcome of the election. So it's based on numbers that are gained by the various electoral contestants, independent or party. So there is nothing that is inherently biased towards either political parties or independent candidates in a forfeiture calculation. And therefore, this, in our view, does meet the standard of fairness and the equal treatment of all electoral contestants. Now, I think the other issue that I think the committee must take note of is that the allocation of public election broadcasts is also based on the number of candidates you put with the IC. So the more candidates you put, the more public election broadcasts you get allocated by ICASA. Hence, the possibility of having a party with fewer candidates than the seats won is non-existent because of that other factor as well. Now, this it is important to know that these calculations have not changed from current Schedule 1B, other than the inclusion of independent candidates in circumstances where an independent gains more than one seat rather. The method of recalculation maintains inter-party proportionality, because that's very important. It's related to the electoral performance of each electoral contestant and retains intra-party proportionality, which accords with the constitutional demand for proportional representation in general. And it's also used when we do excessive seats in local government election. Now, we have 3 illustrations, and I would ask that, Eddie, we go to the first illustration to show that this can go either way. In this illustration 1, we have Party A at 8,700 votes, Party B 1,150, Party C at 400, Independent 1 at 900, and Independent 2 at 200. Now, using the Droop formula, the quota is 406. If you apply that quota and divide the votes cast for each of the contestants, Party A gets 21 on the first allocation, 21, with a remainder of 174. Party B gets 2 seats with 338, and Party C gets nothing because the 400 votes don't meet the formula, the quota of 406. So they've not met the threshold to gain a seat, because to gain a seat, you must meet the quota requirement. So they are short, so they don't gain any seats, and their remainder remains 400. And then independent 1, they get 900 votes. Then their first allocation is 2 seats, and their remainder 88. And then independent 2, they get 200 seats, no allocation, their remainder is 200. So your final seat allocation is Party A 21, Party B it's 3, because you've only allocated 25 seats and there are 27 on the roll. So you've got to rank the 2 remainders. So they get an additional seat there. And then Party C also gain an additional seat because of the 400 remainder. And the independent 1 gets 2, and independent 2 gets 0, and that concludes your 27 seat assignment. Now, obviously, an independent candidate can get 2 seats because, as we've discussed in this committee over time, an independent candidate is 1 person, and they can only occupy 1 seat. This situation then triggers a forfeiture calculation. In that forfeiture calculation, we remove the votes of independent candidate 1. However, we retain 1 seat for them. We protect that seat for them. And we do a recalculation based on the balance of the votes, which is now 10,450. Everybody else retains the votes that they garnered in the election. Now, in this example, Party A in the recalculation now, and with a quota of 388, Party A now gets on the first allocation 22 seats. Party B gets 2 on the first allocation. Party C now gets the 1 seat on the first allocation. Independent 1, it's out of the equation because we've removed their votes and we've protected the seats already. And then independent 2 still does not get anything. And then you're allocating on the first allocation 25 seats, which means there's an extra seat that has to be allocated. Then you look at the remainders. The biggest remainder there is 374 from Party B. So your allocation, your final seats as allocation is 22 for Party A, 3 for Party B, and then 1 for Party C, and 1 for Independent 1, and then that gives you your final seat assignment. So let's go to illustration 2, and the logic is really the same. Now, a slightly different figures here. Here you'll see that Party C and Independent 2 gain seats on the highest remainder, and they retain the seats in the recalculation. And the import of this is really to indicate that depending on the electoral performance of each candidate, things can go this way or the other way. But the determinant is not necessarily the formula being structured in a manner that favors or has a bias towards. It's what each electoral contestant gains in the election, and so on. And this is geared to maintain inter-party proportionality, because we did state that the effect of independence is a distorting. They have a distorting effect in general. So you've got to look then at your inter-party proportionality. Now, in this example, Chairperson, the total votes here, it's 11,350. And again, Independent 1 gets 2 seats. That triggers a recalculation. And in that recalculation, Independent 2 gains a seat, as does Party C. And just to re-emphasize, this is because of the votes they garnered. This situation is possible and arises purely on the basis of their electoral performance, nothing else. And then another illustration, the last one, it shows here we have the total votes as 3,987, and the final allocation is party A 7, party B 5, party C 1, and then an independent one gets 2 seats again, triggering a forfeiture recalculation. And in this case, party C gains an extra seat in the recalculation, which is, if you want to use the words, a smaller party. So there is nothing inherently inbuilt in the formula that supports bigger, better performing political contestants. It depends, as I say, on the electoral performance of each electoral contestants. That's one. Two, it maintains this formula, the recalculation formula maintains an inter-party proportionality, which is demanded in terms of the Constitution. We can move on, Eddie. Now, there's an issue that has been, as part of the submissions received, that the Commission wrongly advised Parliament in the NCOP. The Commission's position is that they have not wrongly advised Parliament, and that has been made plain in 2 formal letters to the person who made the submission. We believe that we are correct in the manner in which we articulated the scenarios that we constructed and presented in the NCOP. Next is the we can move, because it's a repetition here. We can move to the next slide. Is the issue of where an independent candidate wins more than 1 seat. The bill as it stands proposes that we look at the highest proportion as against the highest number of votes. And the issue really is to ensure that the independent candidates receive the seat in the region where they've registered the highest proportion of votes, which means taking into account the performance of the rest of the participants in that region, rather than just looking at the most votes. So they get a seat where they performed much better in proportion to everybody's performance in a particular region. Essentially saying they get a seat where they are the strongest, or where they have the strongest support. And again, the use of that language is to ensure that there are no interpretation issues. It's clear and simple for every person to understand. So, Chair, I think we can take leave of that one and go to the other issues that were raised. Now, the other issue that was raised relates to the filling of vacancies, and 2 nuanced issues were raised in relation to this. One, that if a vacancy arises mid-term on account of a caused by an independent candidate, then a recalculation has to happen. And in that recalculation, all electoral contestants based on the votes garnered in the current election are in contention. Not only the independent candidates. And the reason for that is simple. We can't protect that seat only for independents, because it may be that there are parties, small or big, that have greater number of votes than that independent. Now, if you protect it only for independent, what about the views of those voters who voted that next available party? That's distorting the electoral outcome by protecting it for a category of participants instead of looking at everybody, bring everybody into contention. That seat may go to another independent if the strength, the electoral strength justifies that, or it could go to a next political party based on their electoral performance. And that's a consequence of an election where you consider an outcome in terms of the numbers that each political entity gained in the election. Now, why are we discarding the votes of the independent candidates who caused the vacancy? Because they're out of the equation by definition. They've caused the vacancy, they're leaving, and you've got to factor them out of the calculation. If you retain their votes, you're gonna come to the same outcome. You're not going to have a different outcome. So you've got to factor them out and do.
Chairperson?
Yes, Mr. Matonsi, I think we've lost the seat.
I'm not sure if it's me. I can't hear Mr. Mamabul.
Yeah.
No, I was saying, Chair, I'm still here.
Okay.
Just the last point to conclude, and I'll hand over back to our chairperson, that this proposal implies that one independent necessarily reflects the preference of voters of the next, purely by virtue of being an independent, and it is not so. The political platform of independence is not the same. We can't assume because they're independent that necessarily they share a policy platform. We can't make that assumption. And that concludes our responses, Chairperson. Thank you very much.
Thank you very much, CEO. Commissioner Mieta, is there any matter before we invite the Parliamentary Legal Service?
There is no other matter, Chairperson. I incorrectly said there were 3 issues. There were 4: the wrong quota, the forfeiture, the issue that Parliament was wrongly advised by us, and the filling of vacancies. Those were the issues we needed to respond to coming out of the submissions. We thank you very much, and we'll take questions later when they arise. Thank you, Chairperson.
Thanks very much, Chairperson. We'll now invite the Parliamentary Legal Service or the State Law Advisors. I'm not sure how they want to interact on the item.
Afternoon, Chair. It's Talana. I just want to make sure that everyone can see the presentation.
Yes, Talana.
Thank you, Chair. So CLSO will deal with two issues, Chairperson. I'll be handling the legal issues surrounding the signature requirement.
Sorry, Talana.
The proposal that
Yes.
was made in that stupid letter is like.
Yeah, I think, can we assist each other, IEC? Thank you. You can proceed, Talana.
Thank you, Chair. I'll continue. As I said, I will be handling the signature requirement, the legal issues surrounding the signature requirement, and Dr. Kassan will be handling the technical issues surrounding the formation of the panel. Before we begin, we'd like to set the context of this presentation. During December 2022 and 2023, the Portfolio Committee on Home Affairs advised the proposed amendments to the bill as received from the National Council of Provinces. We have considered the 11 substantive submissions that were received from the public. So the purpose of this presentation is to respond to only those legal and constitutional issues raised in those submissions. We've also limited our responses to the submissions made in respect of the amendments advertised as per National Assembly Rule 307, which limits the Portfolio Committee to only considering amendments proposed by the NCOP. Policy issues have been left to the executive to respond, and technical issues have been left to the IEC in terms of to respond to Schedule 1A, and which the IEC has responded to. Regarding the signature issue, there are three aspects of the signature issue I'll be dealing with. The first aspect is that the signature threshold for independent candidates was far too high. The submission illustrates that the 20% signature requirement for independent candidates is considered too high and is an unreasonable barrier of entry, as it approximately amounts to 15,858 signatures in total. And this would be far too high for IECs to contest an election. Our response is as follows. In Richter versus Minister of Home Affairs, the court stated that the electoral law must aim at enfranchising and not unduly restricting the rights of citizens to vote and stand elections. The purpose behind the use of signatures is to determine voter support eligibility, seriousness of the candidate to contest the election, and to avoid lengthy ballots. However, the threshold set for those signatures should be reasonable. The factors that must be considered when evaluating reasonableness can be obtained from the Constitutional Court judgment of Bartos Starfishing versus Minister of Home Affairs. There, the Constitutional Court relied on the English judgment of Winsberry, and O'Regan J held that there are various factors that determine reasonableness. These factors include the circumstances of each case, the nature of the decision, the identity and expertise of the decision maker, the factors of the decision, the reasons given for that decision, the nature of competing interest involved, and the impact of the decision on lives and well-being of others. Considering the factors, the committee must cast its mind back to how the decision of 20% was made. The committee may recall that the history behind the inclusion of the 20% signature requirement, to which counsel for the DHA has illustrated, originally the bill required an independent candidate to complete the prescribed nomination form with at least the prescribed minimum number of signatures of voters whose name appeared on the segment of the voters roll for the region or province that the independent candidate was standing for. During the deliberations in the Portfolio Committee and following public engagement, it was then proposed that the minimum requirement or formula to quantify that minimum should be included in the bill. The prescribed number was moved from 50% to 30% and is now at 20%. It was then further agreed that parties not represented in the National Assembly or provincial legislatures should have a similar requirement. And it was also agreed that once an independent candidate has representation in the National Assembly or provincial legislature, they would no longer be required to fulfill this requirement. We argue that the process followed by the committee was reasonable, and accordingly, could be argued to have resulted in a reasonable decision. However, the IEC, as experts on the practicality of garnering signatures, is best placed to advise the committee if the requirement of 20% will result in unfairness in practice. The second issue relating to signatures was that independent candidates should submit 1,000 signatures like parties. The submitters had illustrated that parties submit 1,000 signatures upon registration, and similarly, independent candidates should submit 1,000 signatures. Our response is that submitters may be conflating the issue and are confusing the requirements relating to registration with the requirements relating to contestation. The Electoral Commission Act, read together with the regulations, sets the following registration requirements for parties. A deed of foundation signed by 1,000 registered voters, this is for the National Assembly, 500 voters, this is for the provincial legislature, and 300 voters for the local government. If a party is registered but does not have representation in the National Assembly or provincial legislature, there is a further requirement of contestation, and this is where the 20% signature requirement comes in. Independent candidates are required to fulfill the same requirement of 20%. However, an independent candidate will not have to fulfill this requirement at every election, should they have been elected to either in the National Assembly or a provincial legislature in the previous election. And lastly, the third point when it comes to signatures is that the new requirement for registered unrepresented parties provides, submitters argue that this requirement that unrepresented parties need to provide the same amount of signatures to contest an election is discriminatory and offends the right to freedom of association. They also argue that parties who are represented in the National Assembly, provincial legislature, do not have to have the same requirement. Our response is as follows. It could be argued that the provision does differentiate between two categories of parties, i.e. parties and ICs who have representation in the NA or the provincial legislatures, and parties and independent candidates who do not have representation. However, once again, we would like to point out the principles of Harkson versus Lane. Should a provision differentiate between people or a category of people, the differentiation should bear a rational connection to a legitimate government purpose. It is understood that the legitimate government purpose is to mitigate a possible extensive ballot paper. Parties who do not have representation in the National Assembly or a provincial legislature should show good faith that they have the voters' public support. The reason why the signature requirement is not imposed on parties already represented in the National Assembly or provincial legislatures is because they have illustrated voter support already obtained by already obtaining a seat in the National Assembly or the provincial legislatures.
Good morning, Chairperson and honourable members. This is Daksha. I'll be taking over the presentation from now. As we heard from Adam's presentation yesterday, there were many issues raised in relation to the panel and largely questions around whether Parliament should be more involved in the appointment of the panel, the reporting requirements and so forth. We are of the view that those are policy and political considerations that the Portfolio Committee should make and have therefore not engaged or addressed those questions, but have rather limited our presentation to two drafting issues that have emanated from the submissions. The first question that arose in the submissions was, why does clause 23 dealing with the Electoral Reform Consultation Panel not form part of the Principal Act, but will only form part of the bill? Our response to that, 23 of the bill establishes the Electoral Reform Panel, which will be constituted only for a particular period of time and be tasked with very specific activities and responsibilities. The panel is intended to be a once-off activity and not a permanent feature of the electoral system. Therefore, it is for that reason that the provision relating to the panel will not be incorporated into the Principal Act, but will only form part of the Electoral Amendment Bill, namely the Electoral Amendment Act of 2023, once the bill is enacted. The clause, while only forming part of the bill, which will become an act once enacted, and not part of the Electoral Act of 1998, is still enforceable and will create the obligations placed on the minister to establish that panel as stated in that clause. The second issue that was raised in relation to the wording of the clause was that currently the clause reads that within 4 months after the commencement of the section, submissions have been made to change the word section in clause 23(1) to the word act, so that it reads within 4 months after the commencement of this act. And the reason that submitters have proposed is that keeping the word section in this clause brings the possibility of commencing the section at any time subsequent to the commencement of the rest of the bill, and the process of establishing the panel could be delayed. Our response is that the clause as currently drafted, by referring to commencement of the section, does give the president some flexibility or room to enact this section on a different date to the rest of the bill coming into operation, should there be any reason to do so. For example, if there are operational requirements. Drafting the provision in this manner was to avoid having to make any further statutory amendments should the circumstances arise that this particular section cannot be brought into operation at the same time as the rest of the act or the bill. Should there be no reason for this section to come into operation at a different time to the other provisions of the bill, then the general rule is that this section will also come into operation when the rest of the act commences. That is on the date determined by the President by proclamation in the Gazette. Thank you, Chairperson. That concludes our input for today.
Thank you very much, colleagues, for your comments. And I'm now going to invite members to interact with the presentations. And then we therefore will establish how we're going to carry the deliberation informed by what members will have been advised. The IEC has presented Parliamentary Legal Service and the Home Affairs. We'll also invite them to comment on or respond on the issues that will be arising from the discussions. We'll start with the Honorable Pillay, Honorable Van Merwe, Honorable Roos, Honorable Tito, Honorable Kanyile, Honorable Mohale, Honorable Lehwase, Honorable Molekwa, and Honorable Motise. In that order, we can proceed, Honorable Pillay.
Good morning, Chairperson and all colleagues. Thank you very much. Chair, let me say that receiving these presentations from our stakeholders, it gives us, I think, a clear understanding of how we should be able to proceed and what would be required from us. Chair, I think we had agreed yesterday that we will take the presentations and then perhaps deliberate after we've received all of it. But I think there's two things I wanted to just make mention of in response to what we've received. The one is in respect of the highest votes versus proportion. And I think that members may recall that at some point, in one of my submissions, I did say that when you look at KZN and Gauteng, they are bigger in terms of population and voters. And you find that you can't take a highest number of votes, but rather proportion. So I think that one makes perfect sense that when we look at proportion rather than highest votes. I also think that in terms of clause 23 that was just presented now, it makes perfect sense because it's actually for a stipulated time period. It has a start and a finish. And I think that it's important that we emphasize on that so that it doesn't be something that is permanent, and it is not permanent because it's required to be a discussion after that on a very important topic, and that's on electoral reform. But Chair, I wanted to also further propose that it would be allowed as members of the committee to be given some time to go through all of the presentations yesterday and the presentations today, be able to deliberate, but also to be able to consult respectively, and that perhaps we should have our deliberations or discussions on the Tuesday meeting and not tomorrow. It's just a proposal that I'd like to put forward, but perhaps we can hear what other members are saying. But also to say, in saying that, we have to be able to work with speed. As a committee, we want to be able to finalize this process before the 28th. And I hope that we can be able to just push full steam ahead in order for us to be able to do that. Thank you.
Thank you, Honorable Pillay. Honorable Van der Merwe.
Good morning, Chairperson. Good morning to our colleagues, and thank you very much to everyone for the presentations. I do take the point that maybe it would be important for us to reflect on some of the issues and then to take it maybe to our caucuses and then come back to debate these issues on Tuesday. I don't really think I've moved from the issues that I raised in our meeting yesterday. I take the point, all the presentations that have been given to us today have touched on the issue of the signature requirements and how we've landed on the 20%. In fact, Advocate De Beer did mention the fact that previously they advised that signature threshold was too high, that we went for 20%. And today he says that we might even be able to consider as a committee 15%. And that remains my view, because our presentations or the public inputs that we have received clearly says in summary that they believe that the threshold remains too high, that it's an excessively high barrier, that it constitutes unfair treatment, that it's a form of disenfranchisement. And the question really then becomes, what is the difference between 20 and 15%? And should we not then the lower threshold in order to err on the side of caution? Because in the presentations that we've received, there was a mention that if this is referred to a court, the court will, if it's taken on a court review process, that even the court might regard that 20% as unconstitutional and unfair. And of course, we do have different views on some of these issues, but we will debate that at a later stage. On the issue of the panel, I heard what Advocate De Beer said, but the Advocate De Beer says that there is checks and balances in terms of the appointment of this panel. In fact, he says the minister doesn't have a free hand in appointing. But the question that really arises for me is, what is the harm if we want to have an inclusive process? What's the harm of making this a process where Parliament appoints this panel? Because the power to prescribe an electoral system is vested in the National Assembly in terms of the Constitution. That is why we are engaged in this current process. That authority doesn't sit with the executive authority. And therefore, I don't see the harm in Parliament driving the process of appointing a panel. That panel can report back to an ad hoc committee of Parliament. And so that panel then can be appointed through an inclusive process, again, where it's a process that involves the minister and the IEC. And I just think that if we make it a process where we vest that power of picking candidates from a list, appointing them, and then I heard Advocate De Beer says, yes, that the minister has to consult the IEC. But if he's only consulting the IEC, he's not consulting Parliament, and we represent hopefully the wishes of the public out there. So, those remains, I did make the same points yesterday, and it remains my view that I think we need to have a more consultative process in this regard, and that the power shouldn't solely rest with the minister. And those are my views for now, Chairperson. I think I support Honourable Pillay that we go and consult and that we come back on Tuesday to debate these issues. Thank you, Chairperson.
Thank you, Honourable Van der Merwe. Honourable Roos.
Thank you, Chairperson, and thank you to every stakeholder that presented. I think the presentations were tremendously beneficial. Firstly, Chair, I do agree with Honourable Pillay's proposal to have tomorrow's discussion on Tuesday. Just a few key points though on what has been said today, starting with the signature threshold. And I think it's important Chair, you know, there's a total emphasis in the public participation input on the rights of candidates. But many nations have realized the need for thresholds to avoid ungovernability in fragmented legislatures. So, Chair, you know, this isn't something that we've just come up with as a committee that is unique to this bill. There's definitely a precedence for it and a need for this. And we certainly agree with the parliamentary legal advisors that, you know, incumbents have proven that they have enough support to gain a seat. And they also make an important distinction between registration and contestation. It's a very important distinction. You could register a political party or register as a participant and only later decide that you want to contest an election. But registration doesn't put you on a ballot paper, doesn't incur costs to the IEC. And again, you know, if you look at the threshold and we look at the inputs from the legal advisors about the factors of reasonableness, you know, it talks about what are the reasons for this decision, and we've spoken about it at length. What is the nature of the competing interests? So there are competing interests. It's not just the candidate, as much as the Constitutional Court said that independent candidates should be able to compete in elections. There are also the interests of the voters that we do need to consider. So there are two sides to that story. And then the impact of the decision on the lives affected. So again, it's not just the lives of participants in the election or those that want to stand for election, but also the electorate in general, and how practical it's going to be to vote and understand the ballot paper and make an informed decision without getting confused with a variety of options. And Chairperson, yesterday I mentioned that DRC ballot paper, and I did put it on Twitter again, and I think I was wrong. It was over 2 meters wide. This thing was absolutely massive. And I don't know how you would go through that thing and make a decision. So it's not that there's absolutely no rationale to this. And I think everybody needs to consider that there are competing interests involved. It's not just the candidate, it's also the electorate and the fairness of the election and the practicality of the election from a voter point of view. Chairperson, then talking about proportionality, just a comment on the presentation of the IEC, and I think we have discussed this at length. But the question, it always remains that we're moving away from a system where the proportionality is first calculated. So the system now, all the votes are tallied, and then you first work out the proportion that each party is entitled to, and then you go down and work out seat allocations and remainders, etc. And maybe a party or somebody could get one extra seat. But it's, the figures that we've been shown are very small figures. This committee's received a report that does a simulation on the 2019 results, and it shows that the effect is much more serious than that. And there's no doubt it can help a party that gets less than 50% of the votes to get more than 50% of the seats. But Chairperson, we have discussed that ad nauseum, but I think the one important technical point as well is that, we should note that we talk about here in the what we've received, that the candidates can lose their seat due to the recalculation. But I think it's just important to note as well that that calculation is not complete until the full calculation is complete. So if you had a first calculation and now somebody might have got a seat in that calculation, and then you do a recalculation and they lose it, they didn't have that seat in the first place. That recalculation is part of the overall calculation, and only once that is finished, then you have a seat. So it's, you're not losing your seat as part of that recalculation. That's just a technical point, Chair. And then finally, in terms of the electoral reform consultation panel, I think we had discussed this at the end of last year. And I agree with Honourable van der Merwe that the portfolio committee should be playing a leading role in appointing this panel. I think we need to really ensure that we have the right people for the role. And again, re-emphasizing the public participation element of this panel. But I think, Chairperson, we do need an opportunity to properly consider the report that we were meant to receive, I suppose, and that we have now received. So In conclusion, Chair, then I agree with Honourable Pilay's proposal that we have the discussion on Tuesday on these matters. Thank you, Chair.
Thank you very much, Honourable Roos. Honourable Tito. Thank you very much, Honourable Kanyile.
Thank you very much, Chairperson. Greetings to you and greetings to colleagues and all the stakeholders that are in the meeting. We appreciate the presentations that we've just received. Chairperson, I can say that I was largely covered by my colleagues that have spoken before me, especially Honourable Roos. Thank you very much.
Thank you very much, Honourable Kanyile. Honourable Mahale.
Thank you very much, Chairperson. Just also want to state that we welcome the presentations. And then I think the proposal by Honourable Pillay is in order. It will give us time to also consult on some of the issues. Thank you very much.
Thank you, Honourable Mahale. Honourable Lekwase. Honourable Molekwa. Honourable Modise.
Honourable Chairperson, thank you very much. I'm sorry, I'm in a lot of noise. Bear with me, Chairperson. Thank you for the presentation also that has been presented today. Chairperson, I don't want to waste more of the time because of the repetition. I think I've been covered clearly. Thank you very much.
Thank you, Honourable Molekwa. Honourable Modise.
Thank you very much, Chairperson. Let me also take this opportunity and appreciate the presentations that we have received this morning. They have better assisted us and have provided clarity, particularly around the 2 or 3 issues that the committee would have raised concerns since yesterday. Chair, I also support the view by Honourable Pillay that we should, rather than take these discussions to our caucuses and come back on a Tuesday for more deliberations and decision-making from the committee. Having said that, Chair, there's only one matter that I seek clarity on. With regards to the signatures requirements, should the committee decide to change or reconsider the 20% to a lower percentage or higher percentage, what then becomes the process? You would recall that the process comes from the NCOP and it had to be taken back for public participation. I think that's the clarity we did not get from the Parliament Legal Services, that should the committee then decide to change the 20% that they would have previously agreed upon, will that have an impact in us having to take these discussions back for public consultation? Or are we then within the proper framework that we can then be able to reconsider and be able to move forward and take a decision as a committee? Chair, thank you very much. We'll then reserve our comments for discussions that will be taken upon on Tuesday. Thank you.
Thanks, members, for your contributions and proposal on how we must carry these deliberations. There's one matter which I think the Parliamentary Legal Service will have to come back on the issue that's raised by Honourable Modise in relation to the process. Should the committee reconsider the matter that she has highlighted? And I think all the presentations presented here give clarity or affirm to some extent what the committee had considered and the NCOP proposed amendment. The only area which I think is more clearer in terms of where the decision must be taken, and I think as we deliberate on Monday, is on the panel matter. whether it must be parliament or the authority must reside with the minister, that may not need to, or the stakeholders to comment on. It's more clear in terms of how we must deal with it. And I think the deliberations, as we're going to engage on Tuesday, will then have a proper, also the functions in terms of how this matter is going to be carried. If there are comments, Minister or Advocate Pierre, I'll invite you. If Commissioner Miebza, there are comments, you'll come in, and the Parliamentary Legal Service and the State Law Advisors will then respond on the matter that has been raised lastly by Honorable Mutise. We'll then stand off the item as the committee advises that we'll more deliberate on Tuesday to allow a proper processing on the issues, and also noting that some of the presentations were deposited for our attention late. Caucuses of various parties in the parliament may need also to find expression on the matter. I think that will carry it, and tomorrow we'll not have the portfolio committee. We'll stand off a day tomorrow. Minister or Advocate Pierre, you have comments?
Mr. Chair, no comments from my side, but I will also attend the meeting on Tuesday if there are further questions and queries arising from the presentation today and the memorandum that we prepared. Thank you very much.
Thank you. Minister?
Thank you very much, Chairperson, and thank you for the input. At least it is really promising that by the end of February, we will have, not might, because we have got no option to meet the Constitutional Court obligations. The first thing I just want to comment about, Chairperson, is this issue of this proposal from the inputs, and I know that you are still going to debate it next week, but I want to comment about it. I was not there yesterday. This issue of a seat won by independents, when it gets vacated, must go to another independent. I want the committee to be steadfast on this. Honorable Ruos has resolved this issue long ago as far as I'm concerned. And I like to quote him, if you still remember. He said, there is no association of independents. An independent is one person. So the argument that a seat which was held by an independent must go to another independent and the political parties must not contest assumes that that independent won the seats for other independents. It assumes that in parliament, we maybe out of 400 seats, we have allocated that come what may, 10 or 20 or whatever number must go to independents. We have never done so. The independents are contesting with political parties equally. And when the seat is vacated, it must also be contested equally because there can't be an association. That seat belongs to parliament. It does not depend to a group of people called independents. And I think we need to be very strong on that. The second issue, Chairperson, this question by Honorable Mudise, I think is extremely important. We are here where we are because when we proposed certain amendments on the bill from the National Assembly, amendments which we thought were, which we believe were reasonable, we were then told that no, they are very substantial. We need to go back to public hearings. Now, I want the committee, when you go to consult your caucuses, to look at this matter carefully. If we change the threshold from 20% to 15%, as Honorable van der Merwe seemed to be proposing, if then the legal advice or expertise advice is that is a substantial change, we need to go back to public consultation. I will urge the committee to steer away from that because we simply have got no time, and I don't see us going to the Constitutional Court for a second time, nor is it desirable. The more we delay the passing of this act, the more we are disadvantaging the IEC to prepare a free and fair elections. And we are the ones who are going to complain. So I want that matter to be taken very, very seriously. The moment it's proposed that we might have to go back to public hearings, whether in writing or not, I would like this committee to strongly resist that, Chairperson, because it's very important. The third issue I just want to raise, I'm just making a comment. This issue of whether a committee or a panel or whatever must be appointed by the minister is a perennial question in Parliament. It always arises. And my suspicion is that it arises out of not trusting each other or out of suspicions of each other's motives. And I'm not sure whether this is going to be a feature of Parliament. When I was in health, a bill was passed to establish the Office of Health Standard Compliance. The Office of Health Standard Compliance gives birth to the Health Umbad, the country's first health Umbad. There was a very, very hot debate about whether the Umbad must be appointed by the minister or Parliament. And during that debate, this is what I said, because I was asked to comment. I asked them whether there is any guarantee that if any committee is chosen by Parliament, we end up with the best committee. And I cited the former boards of the SABC, former boards of SABC, which were chosen by Parliament, lots of, and I don't want to insult Parliament, I'm just giving you facts. And please understand you, my leaders, I'm not insulting Parliament, but I was giving that as an example that the fact that it was chosen by Parliament did not necessarily mean that we end up with good quality. Eventually in health, that debate was won. The minister was allowed to appoint the health Umbad, and Professor Malaga Purumakhoba was appointed. And his first job and his first task is known internationally. And some committee members came to confess that they will not have been able to appoint such a person because they will not have known him. And they were very grateful that they took a decision about how the Umbad must be appointed. I'm just telling you that you are not the first people to be seized with this problem about where the committee lies, but I'm leaving it to you. The last matter, Chairperson, it might look very trivial, or that maybe I'm being over pedantic, but I can see here that we've adopted the abbreviation of an independent candidate as IC, and everybody seems to be accepting it, IC. I don't know where it came from, whether it just came naturally or not, but as I was listening to the first speaker representing the parliamentary legal services, when she pronounces IC and IEC, I really can't get a lot of difference, and it's confusing until you see what is written on the screen. IEC. So, Chairperson, as I'm saying, it might look trivial, but it worries me and it's going to cause confusion in the public. As far as I'm concerned, a common abbreviation of any independent is IND. That represents independent, everybody will understand. If you think this matter is trivial, you can leave it, but I was just making a proposal that let's adopt an abbreviation for independent, acronym SIND rather than IC, because we have got a very well-known structure called the IEC. And this IC is not very different from it. And I still want the IEC to be respected as an independent body stand-alone, not confused with any other structure. Thank you, Chairperson.
Thank you, Minister. Commissioner Miapsa, comments?
Thank you, Chairperson. 3 comments, and we are covered. One is in relation to the submission made by Legal Services, and if I'm not mistaken, is Telana. Telana, in dealing with the issue of the quota, was suggesting that the IEC would be the best institution to advise on whether the quotas are appropriate or not. I wanted to say we hold the view as we have previously indicated, that we gave the different thresholds and indicated that we believe this is a policy issue. In line with the Rechter matter, we thought it was a policy issue. We still believe it is a policy issue today. And we want to ask that it be considered as such. The second issue we wanted to raise was in understanding what appears to be a common proposal that tomorrow's meeting be moved and today's discussions be referred to next week. The minister has touched on the issue. We want to, if it is possible, to obtain clarity as to what the impact of this would be on the proceedings as was initially scheduled for this to be finalized by no later than Tuesday next week. We say so because it is absolutely critical, as the minister has indicated. And we do think it is important for all of us to avoid another delay and later in the day going back to a situation where we have to contemplate should the courts be approached and so on and so forth. We are anxious that finality is had. The last issue is the issue that was raised by Honorable Roos on the illustrations used. I want to submit that today's illustrations indeed used very lower figures, but to prove a point we have made before. It does not deviate from the fact that in truth, and from what we can see from the simple illustrations we are using, there is no intention. The illustration indicates that no one is intentionally favored or disadvantaged. That's really the simple submission we are making in this illustration. We make those submissions, Chairperson. Thank you very much.
Thank you very much, Commissioner Miebza. Talana?
Hi, Chairperson. Myself and Daksha have been discussing the question regarding whether they would need further advertisement following a decision if the committee decides to lower the threshold to 15%. We are of the opinion that it wouldn't require re-advertisement because this is not an amendment that is affecting a new category of people, or it's a new amendment in totality. We believe that it's an amendment that would have followed from an advert. So the public would have had ample opportunity to engage with that amendment. However, Chairperson, we would like to take this question back to our senior in our unit, just to discuss it and ruminate on it more. And we will get back to the committee on Tuesday when the committee deliberates. Also, Chairperson, we'd like to illustrate that we are worried about time and the pressure that it will take in terms of settling the bill when it is final. So we'd like to just let the committee bear that in mind in deciding when they should meet next. And that's it.
Okay. No, thanks very much. I think the request to stand off tomorrow's deliberation is informed that members need to consult and also pay attention to the issues that we raised in terms of the presentation. Well, all of us fully agree that there's no time and we must conclude this process so that we're able to allow the IEC to interact with the process once the bill has been presented to Parliament. Now we'll carry that decision that we must proceed to deliberate on this electoral amendment bill by Tuesday and perhaps conclude Tuesday if there's any other area that we may need to deal with. We'll interact with it with both the legal service. We'll do an in-house interaction, Telana, immediately tomorrow on the other issues that have been raised that we're going to consult, so that we don't wait for Tuesday on the matter whether committee may need to consider to increase the percentage or lower it, and what therefore will be the course of action. So we'll do that. You know that yesterday when we opened, we had committed that it would be important that we conclude this process before SONA, so that when Parliament, the first item in the House should be this electoral amendment bill debate, to give time for also the President to look on the electoral amendment bill. There's no posture to request for another extension. I think that should not be in our thinking. We must just work closely to this matter. The second point is that I don't think that it was going to be Parliament, since its inception, has appointed task team or other committees to deal with this matter or the other. And there were reasons to that extent. Ministers or cabinet have been appointing panels to do or to conduct this matter or this the other. The IEC has done the same to appoint the panel to consider certain subjects which relate to our work. So I think we may need to leave that matter and without justifying why Parliament can't do it or the minister can't do it. Let's come back and deal with that. I'm trying to caution the minister in terms of how he has commented on the roles that he plays and Parliament plays, so that we must not go out of this meeting with different views in terms of the comment the minister has responded on. So it's important to draw that line that there is a executive role that Parliament does in terms of its functioning and members, and also the minister that you do. I'm trying to work outside your comment in terms of how you reflected towards this process that we must engage on. So we'll then have to reconvene on Tuesday, and Telana with the legal team will then have to reconvene tomorrow to thresh out some of the issues that have arisen from the presentation and how we must work towards Tuesday, how we're going to also bring up the draft C list so that members consider that. Thanks very much. Is there any other matter, Mr. Matonsi, outside what we were resolving on?
No, Chair, there's no other matter.
Okay. Thanks, members. That's how we're going to deal with the matter in the next session. The responses that the IEC Commissioner Miepza has given are noted, and all of us, I think the comments that we've made to this process will then take more deliberation once you have satisfied consultation on the issues, and also going through the presentation that have been taken for our attention. Thanks very much. The meeting stands adjourned.
Thank you, Chairperson.